Two landmark rulings by Europe's highest court, one allowing, one forbidding Muslim women from wearing the headscarf at work. In the case of Belgium, it was company policy, and that was upheld. In the case of France, the court found that a design engineer was unjustly fired over a customer complaint about her Islamic headscarf.
In Belgium, a receptionist lost her job of 3 years when she told her employer she wanted to start wearing a hijab. In France, it wasn't until a client complained that a software engineer was asked to remove her headscarf. When she refused, she was fired. According to Europe's highest court, the companies had the right to dismiss their female employees.
The prohibition of wearing the Islamic headscarf, which derives from an internal rule of a private company, prohibiting the visible wearing of any political, philosophical or religious signs in the workplace, does not constitute direct discrimination.
The court clarified that a company would be guilty of discrimination if they did not have such a rule in place. The decision applies to all religions and political symbols, but it's seen as targeting the Islamic veil in particular. The question of whether or not Muslim women should have the right to cover their heads and faces has become central to Europe's debate about multiculturalism. Tension surrounding the question has been reignited in recent months as nationalist parties gain traction. Austria agreed to limit full-face veils in public spaces in January, 1 month after the country's far-right party nearly won the presidential election. In Germany, where there exists no nationwide restriction, Chancellor Angela Merkel suggested a partial ban in December as her Liberal Conservative Party looks toward this fall's federal elections. In November, Dutch MPs backed a bill banning the full veil in public spaces, a reflection of the rising influence of the far-right Freedom Party. France and Belgium became the first European countries to pass laws banning the full-face veil in 2010.
For more, let's go to Birmingham in England and Jonathan Chamberlain, attorney specializing in labor law. Thank you for speaking with us here on France 24.
My pleasure.
What's your reaction to these verdicts? One saying, yes, you can ban the Muslim headscarf if it is company policy to keep all religious accoutrements out of the public eye.
Well, the verdict I don't think quite says that. The verdict says that you can have a dress code, you can have a policy, but that if it is going to affect people wearing symbols of their religious faith, their religious affiliation, then you have to be able to justify it. And justification is a technical European legal term. It means a proportionate means of achieving a legitimate aim. Now, what the court said was that if you have customer-facing roles, then clearly wearing a company uniform is a legitimate aim. But the court didn't say anything about justification. So, for example, in the UK, we've had a case with British Airways where one of the check-in staff wanted to wear on her British Airways uniform a small cross. And the UK courts eventually said that that was fine because there was nothing in the wearing of the small cross that got in the way of the company uniform. And you can see, for example, that translating in the case of a headscarf. Now, a veil is something else entirely different, because if you're customer facing, then as the expression says, the customer wants to be dealing with you, communicating with you. So I can quite see that the result will be different in the case of a veil. But it's hard to see how this decision will have the effect of banning headscarves in the workplace.
And as you mentioned the case in the UK, the laws differ across Europe. Can a European court really give one-size-fits-all ruling when it comes to the headscarf?
No, and they didn't do that. What they said was that the nation states, the courts of the various member countries, could take into account the national situation. This has been pushed back down onto the national courts. So I can well see, for example, in France, where there is a very strong culture of secularism, that the courts might look at justification, this technical legal concept, in a very different way from the way that we look at it in the UK. You could have cases of similar facts having different results in different member states.
Jonathan, is justice blind, or do you get the senses from this ruling that it sort of corresponds to the way that values are shifting in Europe?
I think very much the latter. Justice can't be blind. You go out onto the streets and you can see that Europe is made up of many different peoples, of many different religions, many different ethnic backgrounds. And what the court here is trying to do is come up with a sensible compromise so that people can live and work together, so that they can practice their religion, but also that, in this case, companies can impose sensible rules that help them to deal with their customers. And it's a question of balancing those interests. It's a difficult task, and the courts, I think, are coping with it well.
Jonathan Chamberlain, many thanks for speaking with us from Birmingham.
Not at all. Thank you.